Right. Okay, good morning, everyone. Today is Tuesday, September 10th, 2024. The current time is 9:37 a.m. This is a pre-hearing conference in the matter of Mila Depina-Cooley, case number 23-015-SU, before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We're convening remotely via Zoom, and this pre-hearing conference is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over the pre-hearing conference today. My name is Alex Utz. I'm a legal fellow for the Post Commission, and this matter is now before Judge Fishman.
All right. Good morning again. Counsel simply state their appearance for the record.
Timothy Harnett.
Oh, I'm sorry.
Go ahead.
William Broderick for the respondent.
Timothy Harnett on behalf of the Division Police Standards.
All right. I guess the last order I entered was when I heard from you folks that you were unable to reach an agreement as to a voluntary decertification agreement, so we had put the pending motion from the division for default and final decision, or in the alternative summary decision, on hold while you folks were talking about it. So I think we're back to that. As I recall from our last meeting and from the order I issued, that I was advised that the division had withdrawn so much of the motion that sought to enter a default and final decision, and was relying instead on its request for a summary decision. Is that correct, Mr. Hartman?
That's correct.
And has anything happened since I last heard from you folks, or is that where you both understand that we are at this moment?
I think that's where we are at this moment.
I agree.
Okay. So I'm going to hear you on the motion. Why don't I just have Mr. Hartnett, why don't you address the motion itself on the merits?
Sure. Summary decision should be issued because there's no genuine issue of fact here, and revocation of the respondent's certification is required by law. The division is moved to revoke the respondent's certification under Mass General Laws, Chapter 60, Section 10A1, because she's been convicted of a felony, and there's no dispute that she's been convicted of a felony. On May 8th, 2023, she was convicted of receiving stolen property in Suffolk Superior Court. She was in fact sentenced to the House of Corrections for 60 days to be served, and the balance suspended for 1 year with probation. So she's gone through that whole process. There's no alleged procedural indeficiencies here that would prevent us from moving forward, and summary disposition is authorized and proper, both under regulations and SJC case law, which I cite in my motion. Under the regulations, our regulations, 555 CMR, the adjudicatory hearings such as this are supposed to comply with the formal rules of adjudicatory rules of practice and procedure, which is 801 CMR 1.01, and under 801 CMR 1.017H, when a party is of the opinion that no genuine issue of fact relating to all or part of the claim, there is no genuine issue of fact, and then they're entitled to prevail as a matter of law, they may move with or without affidavits for summary decision, which is exactly what we're doing here. The regulations also say that our regulations, 555 CMR 1.10, paragraph 4, says that the commission's hearings shall be adjudicatory proceedings conducted in accordance with Mass General Laws, Chapter 30A, Sections 1, 8, and 10 through 14. So Mass General Laws, Chapter 30A, Section 13, expressly talks about the exceptions to the hearing requirement, and says that where an agency is required by any law to revoke or suspend or refuse or renew a license, as the case may be, without exercising any discretion in the matter on the basis of a court conviction or judgment, that they're not required to have a hearing. And that's exactly what we have here. We have someone we have a situation where there's no dispute that she's been convicted of a felony, and the statute requires the commission to therefore decertify her. For those reasons, I'm asking that you issue a summary disposition, and you find no genuine issue of fact exists, and that she was convicted of the 2 felonies, and therefore she should be decertified.
Let me ask you before I hear from Mr. Broderick, just for clarification purposes, that there was an indictment that was pending for an extended period of time before the case was brought to trial, if I remember correctly. And during that period of time, do I understand that the indictment was that the statute under which the indictment changed with regard to the amount of money involved in the offense?
Yes.
So at the time the case was actually heard, the amount of money involved had gone from $250 to maybe $1,500.
Yeah.
$1,200. Okay.
Yeah.
But she was convicted under the earlier version of the statute. Is that correct?
Yeah, and I think that was litigated, and there's case law that says that it's the statute as it applies at the time of the indictment. And so I think that's there. I think that was resolved in that case. I don't know all the details of the case, but my understanding of the facts is that I think it's kind of a non-issue, because I think that the amount in question would have probably been over that $1,200 anyways. So I think it was sort of may have been a non-issue. I'm not sure, that it didn't seem like it was fully thought out. But either way, she was convicted of a felony. So, and she didn't deny that in her response to the order to show cause.
And do you, I'm sure I hear more from Mr. Broderick, but I think I read as well the response that an appeal had been taken from that conviction, and that the appeal, at least the time of submission of the opposition, was still pending. I think I know the answer to this question, but I want to make sure the record is clear. Does that make a difference as far as the division is concerned?
No. This case has been resolved. The criminal case was resolved once she was sentenced. And there's case law about that. There's DeMacy versus the State Board of Retirement that talks about that. There's other case law that I cite in my brief. There's also just a general rule, and I don't think I cited this, but in O'Brien versus Hanover, that's 427 Mass 194. The SJC talked about how for res judicata purposes, which is essentially what we're talking about here, that res judicata and issue preclusion comes into play regardless of whether or not there's an appeal pending. It directly addresses that. And that's been consistent with our practice in other cases before the commission. I'm not sure that there's been a direct challenge to it that's directly addressed it, but it's been touched upon in many ways. And people have certainly been decertified with pending appeals. There's been multiple people who have had that. So the fact that there's a pending appeal is not relevant. Plus, the practical reality is appeal, it could be resolved tomorrow. It could be resolved 3 years from now. We don't know. And if she's successful on her appeal, even if she's successful on her appeal, it may go back and be remanded, and she could be convicted again. So there's a million things that could happen. So there's really, it's not relevant.
All right, Mr. Broderick.
Well, yes, she has been convicted, and there is appeal pending. Unfortunately, the district attorney's office has stalled the appeal. They've refused to turn over documents, which were refused to turn them over during the trial. And now, as we're going to the appeals court, we've requested those same documents. And Judge Raschuti ordered them to turn it over when we made the motion, and they did not respond to the motion. The day that he ordered them to turn it over, they filed a motion to reconsider. He is now considering a second document which has been filed with the district attorney's office to explain why they waited so long and why they did not request an extension of time. and did not respond to his order to respond to our motion. The case in the appeals court is currently has been placed on hold for several times now. We're now waiting for Judge Raschudi's decision on the district attorney's office's refusal to turn over the documents, and the appeals court has extended that to September 30th. This has been the problem what we've had from this case. It's one thing to go for the commission now to just blindly say, well, you've been convicted. Well, yeah, she's been convicted. However, the basis of that conviction is upon a number of issues of bias and misconduct on the police officers that were involved here. I think this goes directly to the basis of why the commission was, why it came into existence. You had police misconduct, which arose out of the George Floyd case in Minnesota, and then across this state. So it brought it to a head. The problem was that police departments were not properly supervising investigations and involved certain officers. Unfortunately, this time, this was a situation where you had two rogue investigators who lied to the grand jury, one who actually entered into the grand jury room while the witness was testifying, a witness that he claims he was escorting. That was the basis of the first appeal, and Judge Sullivan dismissed the case based upon that. We also have the lieutenant that was involved in the case, who has now testified in several different forums, and each time he testifies, it's a different story. He's committed perjury. He committed perjury in front of the grand jury. These are issues that are going up to the appeals court. So for now, for the post commission to take one side against one police officer against another police officer, I think the actions of those police officers need to be looked into by the post commission, and that's why I think that a hearing would be helpful in that area, because those two investigators would have to come in and under oath testify to how they conducted their investigation. Additionally, during the trial, while the government's main witness was on the stand, and as by 4 o'clock, the judge stopped his testimony, and he was to come in the next morning. Between the time that he left the stand and re-entered the stand, despite a standing order from the court for sequestration, and the witnesses were not to contact each other, the police officer who was going to testify, Lieutenant Evelyn, confronted that witness. He then tried to convince him to not testify favorably for my client. He then got on the elevator, went down the courthouse, and confronted our first witness and attempted the same thing. He submitted a report to this effect. That report was not turned over to us until after the witness had left the building and was in the wind. So we were unable to question him about that on the stand. We made a motion for a mistrial at that point in time. Judge Raschuti denied that motion for a mistrial. There's been a whole string of irregularities in the grand jury process of this case, and even into the trial. She did not receive a fair trial, and she did not receive a fair trial because of the actions of the two police officers. Something which the post commission needs to look at very, very closely. Going back to the initial stages of the investigation in 2016, before they went before the grand jury, the officers sat down with the district attorney's office. Michelle Granda was the assistant district attorney, and they wanted to prosecute my client. She told them, after reviewing all the documents in writing, that there was no case to take against her. And her suggestion was try to warn her that we will indict her unless she resigns from the police department. They did that. Michelle Granda contacted her attorney at the time and gave her two opportunities to resign or be indicted. And despite the fact that she made a decision that there was no case to prosecute, she went before the grand jury and obtained indictments. So I think that if the commission wants to go blindly into this, they're correct. They can say there's no genuine issue of fact, but in fact there is. Has my client been convicted? Yes, she is. Has. However, we're pretty confident that we will be successful on appeal. In the meantime, I don't think that the commission needs to go down this road in this particular case. We have a case here now, which she has since, just as an aside here, on July 31st, she was terminated by the police department based upon, in part, the conviction. So I think there's been a heavy hand on this from the police department, from the investigators from the police department, and from the district attorney's office. And I think these issues need to come out into the open. They will in the appeals court, and I think that the commission at this point in time may be being used as a tool by these officers involved in the Boston Police Department.
Let me ask you a couple of questions, Mr. Broderick.
Sure.
First of all, are you aware of any, and I'll ask Mr. Hartnett the same thing, but are you aware of any proceedings before the commission related to the officers that you're accusing of misconduct?
There are none before the commission at this point in time. However, I've made, there was a complaint filed against the chief officer involved. His name is Hamilton. And that complaint was made by the same district attorney at the same time this indictment was pending, that he had misrepresented himself in the Dorchester court to get complaints against another individual totally unrelated to this case. She filed a formal complaint against him with the Boston Police Department in 2018. That, as we've been, the allegations we've made along the line here is that he's been covered on this. That report disappeared from the Boston Police Department's files. I went through the whole process of public records, et cetera, and it got to the point where we wanted Judge Asciutti to order them to turn over the records, those particular records, for the purpose of attacking his credibility. And the judge was provided with redacted copies from the police department. We were not provided them. Those are the documents we're trying to get out of through the appeals court. Those complaints were submitted. A request was submitted to the police department and to the public records department of the Boston Police, the city of Boston. And at that time, shortly before the trial, they said their investigation from 2018 was still ongoing, and therefore would not turn everything over. Well, we've now been informed that the investigation has been completed. And where it has been completed, they have 30 days. I've asked for all of those records, and they have 30 days to turn those over. And we believe that will be the point that we can initiate a complaint at post. We can notify them post that there's been some misconduct in this police officer that involves a crime. So it's been a very difficult road because we're running into a lot of resistance from the city of Boston, Boston Police Department, as post has run into the same from some of these larger police departments. They're not turning documents over. They're not informing the post commission of misconduct of these officers. With the outcome of their investigation, that should be the trigger for the complaints against those officers. I don't mean to confuse the issues here, but it definitely involves police misconduct and a bias on behalf of Captain Hamilton.
So, just so I understand procedurally, were any post-verdict motions made before Judge Raschuti that relate to these issues? Like a motion for trial, or?
There was a motion for a mistrial.
Right.
And he said he was taking under advisement. He wasn't happy with what he had heard. We had a sidebar. And the district attorney acknowledged that he told the police officer to confront the witness while they were still under oath on the stand. We have a witness that observed both the district attorney and the police officer involved, Hamilton, pinning the guy against the wall outside the courtroom on the opposite side of the courthouse and confronting him at that point in time. So there was misconduct involved here that goes right into the district attorney's office, as well as I said, the police officers involved. And we have a report to that effect from the lieutenant himself.
So that was all in relation to your request for a mistrial. What I'm asking you is,
I'm sorry,
particularly since you were, it's helpful to know the full scope of things, so that's fine. But what I'm trying to ascertain is whether these issues were raised and the discovery you were seeking were raised in the context of for instance, a motion for a new trial.
No, they're coming up in the issue of the appeal. We need these documents. We don't have the documents, so they are part of the appeal. And that's yes, the motions have been made with Judge Raschuti, and he's ordered them to turn over the documents that we wanted concerning these officers.
Yeah, but for the appellate record.
For the appellate record, yes.
Yeah,
I'm sorry.
Okay.
Yeah.
No, that's all right. I just wanted to make sure I had it correctly.
But we had to go back to the trial judge for those documents.
Sure.
Right. Because he's the one who actually put the lid on them at that point in time.
So even if I had concerns about the matters raised, particularly where there's police misconduct alleged on the other side of this, how do I have any discretion under the law where the statute clearly says in the case of a felony conviction that there's nothing more to talk about, so to speak?
I don't really have a good response to that. I'm going on the basis of, I just don't see agencies ignoring underlying misconduct on behalf of the prosecutors. It's kind of a blind approach to things, particularly where there is a valid appeal pending. Is a case law involved? I can't respond to that. I do not know at this point. Our concentration has been on the appeal. We have Karen Pickett is the appellate attorney on that, and excuse me. So this is what I would say that this is a matter with the purpose of the post is to remove police officers who have been convicted or accused of serious crimes from being police officers anyway. She has not only was she suspended back in 2017 without pay, she couldn't act as a police officer. She turned in all of her credentials, et cetera. If she had even applied to another department, she would have, they would not hire her. She has since been fired by the police department based upon the same conviction. They did not give her a proper hearing at that point in time without getting into the particulars of that, except that when Lieutenant Eblin was testifying, when I asked him questions, he was ordered about his testimony to the grand jury. He was ordered by the hearings officer not to respond to my questions. So, that's on appeal now at the Civil Service Commission. I would point out that in the statute itself, the post statute, it talks about misconduct of police officers testifying untruthfully. And to base, that's the allegation here, and it's pretty evident. It says that police officers who are accused of testifying untruthfully need to be, that notice needs to be made to the commission by the police department. They did not make that notice. That's the allegation we're making here at this point in time. That there was perjury committed by Lieutenant Evelyn before the grand jury and at other occasions. I don't know if you're going too far afield with that.
No, you're not. This is your chance to spell it out, make your record,
yeah.
And also try to persuade me. I guess what I'm struggling with it, even if I am sympathetic both legally and philosophically, if you will,
Sure.
And there's an interesting argument you're making with regard to the role of post, and are we serving our role properly if we're allowing, misconduct by investigators or prosecutors to prevail. But again, assuming that I'm barred by don't have any discretion based on that, isn't it ultimately sort of a legislative remedy that allows for pendency of appeal or issues of the sort that are raised in this case to have some impact? For instance, perhaps staying decertification proceedings pending these, resolution of an issue like this, or being able to address it in some other way. Is there, as I said, wouldn't that require some kind of statutory provision to allow that to happen? No, the post commission is, the whole statute is sort of a work in progress, if you think about it.
I think,
and I'm sure Mr. Hartnett would tell you that he's facing issues that nobody considered that aren't part of the statute, that weren't considered because maybe they were talked about during during debates with regard to the establishment of the commission. But we ended up with the statute we ended up with. And it's not as if, for instance, you're challenging the constitutionality of the proceedings of the statute that we're dealing with, or the proceedings that your client is subjected to right now. It's sort of more of an equitable argument, if you will, that you're making. And again, regardless of how I may feel sympathetically, I'm trying to figure out if there's anything I'd be permitted to do under the law under those circumstances. But let me again, absent sort of an agreement with the division to allow the process, the appellate process, to proceed because of the peculiar nature of the issues that are involved here. But again, I don't know how one could, I'm not sure there's any provision that would even permit me to cause that to happen if I were so inclined. But Mr. Hartnett, why don't you address the argument that Mr. Broderick made?
I frankly don't think that it's appropriate to even really consider this, because it's a matter of res judicata. This is a matter, the allegations he's making are to be resolved in the trial court and the appeals court. It's not for us to decide. It is not, we are not the finders of fact for those criminal proceedings. The only question that we are under both the statute and just, it makes sense, we're not here to retry her criminal case. The appropriate place to do that is in the trial court for motion to vacate the decision or an appeal. There's a process. There's appropriate actors, the appropriate place to handle that. It's not appropriate for us to challenge that. That's the statute says once you're convicted, and we should accept that. And there's everyone who appeals thinks they have a great argument, and I acknowledge that there's a lot going on here, and this may be a great appeal. But I'd also note that there's a district attorney's office who I'm sure has a very different position on a lot of what Mr. Broderick said. And there's arguments both ways, and we have no idea how that is going to turn out. And that's the whole point. That should be dealt with in those courts, and it can be resolved. But as a matter of law, she's convicted. And we have a duty when an officer is convicted, and it's under statutory requirement that when someone is convicted of a felony, they shall be decertified. And that really is the end of the story. So I don't think there's any leeway at all here.
Okay, and do you agree that there's, as far as you know, there's been no action taken pursuant to the commission with regard to these, and the lieutenant or the, what's his name, the investigating officer or any of that? You're not aware of any action against them?
I am not, as a matter of law, allowed to confirm or deny whether or not there's any preliminary inquiries into any officer. That's the end of the story. I mean, I can explain the process. I mean, if we have received a complaint, we would process it the way we would process everyone else, and we would, take it as serious as everyone else. I mean, if it's very old and it's been resolved, there may be limitations on what we're allowed to go back in time and look at. I would note that, because he did mention if there's an older case that was resolved, I don't know. I don't know what's going on. I don't know anything about that complaint, if there is one. And I can't, we can't discuss whether or not there is a preliminary. I can say that there's definitely no administrative hearings related to that. That's all I can say about it.
Okay.
Sorry, it's a confidentiality issue of the preliminary inquiry, so I'm not
No.
allowed to confirm or deny.
No, I know.
Even I'm not even allowed to confirm or deny whether or not we would be considering opening one, because it's all under the confidentiality clause.
Gotcha. I don't want to go down that road anyway, because I suspect that you may not be allowed to unless ordered to do so. But again, that's not an issue I think we're pursuing here now. It's more of a, I really want to know whether there's an open proceeding pending, and as far as you know, there is none.
No.
Right. Mr. Broderick, is there anything else you want to say at this point?
Well, I think just the statute allows the respondent to have a hearing. And that's what we're looking for here, is to have a hearing where we get to bring in witnesses, testimony, and evidence before she is fully dissatisfied. The commission is not put in any kind of a spot here, because she actually has been fired by the police department. She's been without pay and been in a non-payment status since 2017. We're going on 8 years here. So I don't think the commission loses any of its power at this point in time to provide her with a hearing.
But let me ask you this: toward what end? What if you were able to expose at a hearing all that you believe occurred and allege that occurred, and there nevertheless, because the appeal is still pending, there's still a conviction that's that hasn't been overturned? Why wouldn't the result be the same?
Well, I think the result may be different under the circumstances, because by then, with as you say, the commission is kind of flying on its own now. This is, as I said to Mr. Hartnett at one point during our discussions, the commission is very similar to the Civil Service Commission 100 years ago. Growing pains, and it's still growing.
You don't look that old.
No, but I was a captain myself in the Boston Police Department, so I go back to 1969 with the police department. So I've got some experience with them, and with the Civil Service Commission, and it changes. But if in the readings, if you go back 100 years ago, then when civil service was enacted, these are the types of problems that occurred, and much of it ended up in the courts to make those changes. Now the post commission is faced with similar situations. Without a hearing, some of the statutory changes which need to be made, either or some sort of constitutional issues that need to be addressed. As far as hearings are concerned, if the commission now prevents her from having her hearing, none of this comes out. Then we have to wait until the appeals court issues and then possibly chase it down at the Civil Service Commission. But I think it would be to the benefit of the post commission if we have a hearing. And if there's a need for statutory changes, there'd be something to cite for those statutory changes.
Well, given your professional career and mine, isn't Mr. Hartnett right to the extent that the door that this would open if every convicted defendant who believes or doesn't believe, but raises an issue of improprieties in the nature by the DA or the investigating officers, wouldn't they be entitled to the kind of hearing you're suggesting?
Well, I think they're entitled to a hearing somewhere along the line, particularly where they're.
No, I mean, in the setting of the post commission, I'm talking about not
I understand
not as
that.
part of a motion in the court.
It's a public commission. Everything about it's transparent. So all of this information gets floated out there. And if she doesn't have the opportunity for that transparency, to have a hearing, to bring out the misconduct of not only the police officers, but the police department, their supervisors that are overlooking what's going on, and the police department is undermining the post commission. So I think that with the hearing, particularly in these circumstances, I'm not saying under all circumstances, but under these circumstances, I think it would be to the benefit of the post commission to have a hearing, so this information can come out in a transparent way and be a public reckoning for the police department.
Okay. Is there anything further you want to add, Mr. Bronner?
I do not know.
And Mr. Hartnett? Anything further?
No, this is not the forum for public reckoning. I mean, this is not the forum for him to raise his issues on the validity of the criminal case. That is in the appeals court and the criminal court. And there is no issue of fact here, because there is the only charge, the only allegation that we have brought is that she was convicted of a felony. And that is the only thing that's in dispute in this case. She's not charged with, we're not even charging her with committing the crime, the underlying crime. That's not the dispute. The question is whether or not she's convicted, because if she is, it's mandatory decertification. And there is no dispute over that. And the SJC itself has made clear in Corbin versus the Board of Registration in Medicine, this is 444 Mass 837, where it said neither the board statute nor due process required the board to hold a hearing to take evidence concerning undisputed facts. Such a hearing would be a meaningless exercise. And that's the division's position on all these convictions, inconsistent in here as well. If there is no dispute that the person is convicted, there really is no point to a hearing. And this is actually a perfect example of why we shouldn't hold one, because that hearing would be turned into a hearing to argue the underlying merits of the case, and that's just not an appropriate thing to have before the commission. If there are complaints about underlying officers, they can file complaints, and we can deal with those separately. And then anything to do with the criminal case, it should be dealt with in the appeals court, and that's where she will have a hearing to address all those issues. She is not being denied anything. She has the perfect forum for that.
As a matter of curiosity, are you aware of any case so far before the commission where the division has agreed to withhold action or resolution of a pending complaint, pending appeal of a criminal conviction?
Not pending appeal. There was an appeal in a case where the person, they had stayed the sentencing of an individual pending an appeal in a related matter that would have changed the sentencing. That ended up not going in that respondent's favor. And then we moved to lift the stay, and that's still pending. But
But your position,
but our position, but our position was then once you're sentenced, that's the resolution,
Well,
because
that's
that's
my
what the case
point.
law talks about. Yeah.
The stay occurred before sentencing, so that
Yeah, and then once sentencing ended, then then the stay is not necessary anymore, because it's not about the appeal, it was about the sentencing.
okay. All right, well, I'm going to take the matter under advisement. I'll get a decision out to you folks as soon as I can. Thank you both.
Thank you.
Thank you, everyone.